Good evening. Meeting call to order, please. Mr. Clerk, roll call, please.
Councilor Chow.
Here.
Councilor Dakota.
Here.
Councilor Scott.
Here.
3 present.
Good evening, everyone. I'd like to welcome all of you to the City Council Rules and Election Laws Subcommittee meeting. Today is January 30th, and this meeting we're going to cover 2 topics today. One is on the filling the vacant position of a locally elected seat, whether it's council, and probably this would be applied to the school committee as well. Also, the second part is on the censure. These 2 motions was referred to us on the censure side. It's a motion that was made by Councilor Janess, Councilor Nguyen, and Councilor Leahy. And on the to fill a vacant council position, the motion was made by Councilor Leahy and Councilor Janess. I also like for the record to acknowledge Councilor Eric Gitchie is also here. And earlier I saw Councilor Rita Mercia. She might be stepping out to another function in the lobby. She might be joining us as well. And here today also is the city solicitor to answer any questions that we may have or the public may have. Before we start the meeting, I just want to follow the protocol here that to make a disclosure that this communication is remote Zoom participation, and the meeting will be is held in this chamber and it's also accessible on Zoom as well. Before we start the discussion, I see that many members of the public who are here that whether here to listen or to make comment or questions. At this point, I'd like to open to the public first. If you would like to make a comment or anything like that, please come up to the podium, state your name and address. Anyone here in the public that would like to make a statement?
This is about the vacate, right? What was answer?
We'll start, just to be clear, we'll start with the issues on the, to vacate the positions of the council. And you may speak on either issues.
My name is Debbie Belanger. I live at 65 La Plume Avenue in Pawtucketville. We are pleased to see the council motions regarding best practices for adding censure and a procedure for filling vacant council seats have made their way to the Rules Subcommittee. We also hope you will consider including a code of conduct for council members to adhere to, thus non-adherence being a reason for censure. This is still a time-sensitive issue, and we hope it can be prioritized and put in place as soon as practicable. The city solicitor recently provided a motion response regarding the censuring of a councilor, whether that be via Robert's rules or via a policy of Lowell's own, perhaps modeled after that of another city. We expect our elected officials to be held to a higher standard than the everyday citizen. A code of conduct leading to censure should include that a Lowell City Councilor must act conscientiously, reasonably, and in good faith at all times in regard to their responsibilities and interest of the city and welfare of its residents. A Lowell City Councilor must communicate in a manner that is not disrespectful, abusive, and/or threatening toward anyone. A Lowell City Councilor must show and demonstrate respect for law and order and for the public served. If a city councilor is arrested for a crime, especially if they were to be deemed a danger to others, that they be required to relinquish their seat. And I want to add something here. If a counselor has done something that warrants censure, perhaps it also warrants removal. I'm suggesting this as something for you to consider as you research this topic further. If a censure doesn't warrant or lead to a removal, might the counselor be denied the right to chair or participate in subcommittees? In closing, thank you again for listening and taking up this matter for discussion and action. It is a start to creating guidelines for the council to adhere to, a commitment on your part to the community and visitors to our city regarding the high standard in which you will govern on our behalf. We believe this is a great opportunity to come up with some very basic yet expected guidelines that would lead to censure. Thank you for allowing me to speak today on behalf of this group.
Thank you. Anyone else in the public that would like to speak on whether on the vacant position or the censure procedure? Seeing none, before I open to my colleagues, the members on this subcommittee with me are Councilor Dakota and Councilor Scott. We'll take on the issue on the procedure to fill a vacant council position first. There was a motion response to this that was presented back on January 16 by the city solicitor. Before I open to my colleagues, I'm going to ask the solicitor to once again, in case anybody who missed that meeting, just to give us a brief overview on this matter. Mr. Solicitor?
Yes, thank you. So as you mentioned, there was a motion response that was put forward on this issue, and just to summarize, it was sort of narrowed down into two scenarios. One being if a city council seat was vacated and they had run unopposed, and a city council seat that was vacated where there was an opponent. In those scenarios, they're sort of governed by two separate things. There's Chapter 230 of the Acts of 1954, and then there's also Mass General Law, Chapter 43, Section 102. And the Acts of 1954, they govern when whoever, that city councilor vacates a seat, whoever was the next highest vote getter would, they would take over that seat. And then if someone runs unopposed, it would go to the city council by majority vote to fill that seat. So at least statutorily now, the city of Lowell, those are our guidelines.
Thank you, Mr. Solicitor. And also, Councilor Leahy just joined us for the meeting. Welcome, Councilor. Does any, Councilor Scott or Councilor Dakota, do you have any comments or questions? Councilor Scott?
Thank you. And thank you to Attorney Williams for bringing that forward. So what you brought forward to us was the laws that we're living under right now. And now that we have the modified Plan E with the order, the court order, and we've changed the way, we don't have to follow that. I mean, we can move forward and change to a different model. We've talked about this. I think a lot of people were coming forward and saying, I don't agree with Attorney Williams. And I think what you did was bring forward just what the law is stating right now. And I just want to make that clear, I guess, to people that were concerned about what you brought forward. I believe that we should have a special election to fill seats. I think I've made that really clear. I would actually make a motion right now, just to, in the interest of time, I guess to save time, to request the city manager reach out to the state delegation to pull the 2021 home rule petition. So I don't know if there's a second for that.
Motion by Councilor Scott, second by Councilor Dakota. All in favor, say aye. Opposed, say no. The ayes have it. Motion is passed. Just for the clarity on that motion that was just passed, this is to have the city manager reach out to the state delegation to work on filing a motion that would reflect the interest of the council members tonight. Any, Councilor Dakota?
Just for some clarification, City Solicitor. So the state legislature has been kind of sitting on this for the last 2 years, and we've gotten nothing. So if we sent the home rule petition ourselves, we could basically just be in the same boat. Am I off on that, or?
No, I mean, that could theoretically happen. Letters could also be penned, authored and sent from the city council, perhaps explaining the urgency of the situation or any special circumstances, or that we've been down this road before and we haven't been successful. We're, really excited or encouraged by this new procedure moving forward. We'd like the legislature to really take a look at it. So really it would be about just kind of being proactive with it. That can definitely help.
So we'd ask the state reps to refile?
Yes. As Councilor Scott said, there's a motion that's put forward to remove the home rule petition that went forward, because that,
Yep.
it appears to me that doesn't reflect the wishes of, the subcommittee or maybe even the rest of the body. I'm not sure. But it would be to pull that forward, and then a new home rule petition would have to be put together and submitted.
Okay.
And that would be put in from one of the state reps.
All right.
Go, Councilor Dakota.
Just to get further into this, if in fact a home rule petition is awarded to us, I guess, when we're looking at it, maybe a special election, I'm looking at timetables here on what, the first year there's a vacancy. I would imagine the special election would go on. But then after that, if it's next, 4 months left in that councilor's term, are we really going to have a special election? I mean, it would seem to me that the council would probably favor the city council to then vote another person from that district to serve the remaining time of that term. Is that?
So I think that what you're saying definitely makes sense. Obviously, a special election is going to take a certain amount of time one way or the other, 2 months, 3 months, 4 months, I don't know. So to your point, if all of a sudden you're 3/4 of the way through a term,
Right.
a special election might not make sense. So the language that goes into the home rule petition could sort of mirror that. The first 12 months of a term, it could go to a special election. You could have language specifically for the second 12 months where it became an option of city council, whether it was early enough they were comfortable with a special election, or the option to have city council, by a majority vote or a 2/3 vote, whatever is deemed appropriate, to put someone, a registered voter into that spot. Obviously, as you mentioned, it would be important that if it's in a district, someone from that district would have to be put in as in at large. Of course, could be any registered voter. But I think that's definitely language that can go in, and it makes sense.
Okay. I appreciate the comments.
Okay, Councilor Scott.
I did find language, I know I shared it with the solicitor, that is for Watertown, Mass, that has specific language about the first 12 months with the mixed at-large district councilor system, that there would be a special election, and that it also specifies that it would have to be a district councilor, someone that lives within that district. The second 12 months by a 2/3 majority vote could be overruled, and it could have an appointment by the council or not, like perhaps there's 13 months and we decide that there's enough time to run a special election without, it costing the district too much money. And it also has, if that time frame passes and we don't take action, what happens? That the election commissioner's office takes over. And then it has a section about appointment, that if someone's appointed, then they're not marked as an incumbent on the ballot. And I don't even know if we definitely do that or not. So I don't know if this is something that we would request the city solicitor to come back with language similar to this, and then we could discuss it, take a vote at that time, if that would make sense.
That's a great comment, Councilor Scott. I think part of the, the motions passed in the subcommittee, once it go to the full board, will present the same motion. I'm sure there'll be more discussion on it, but to be clear, I think part of the motion, when the solicitor work on the language to have the city manager forward the language to the state delegation to file the home rule petition, is to include many of these finer details, so to speak. If the position would need to be filled more than 12 months, would that be that would reflect like an automatic special election? And I would believe, unless my colleague says otherwise, that would be across the board because we do have a hybrid election system of district and at large. So the special election would be just across the board when there's a vacant position. And if it's less than 12 months, I think we have to be careful with that a little bit. I would imagine that if it's 10 months left in a term, that could easily rationalize that would require a special election. But it was like around 6 months left, and then we would have to, go to council for a vote, and it takes 64 to 120 days to complete the special election. If it were to be special election, that already get you down to about 4 or 3 months. So, if it's under 6 months, would that have to be appointed? But I also would like to have the council have the option, if it's so many few months left, that position could be left vacated as well if it's only 2 months, 3 months. I don't really see the point of spending all that money on a special election. And we do have the at-large councilors, I believe, that could take on the responsibility of representing that district. And as you know, each of the councilors, the district councilors anyway, we represent our district, but we are concerned with the entire city. We don't just say, I'm going to take a vote on this issue because it affects my district. I don't really care about what goes on with the other district. It's just one city. It's just that the role is that we get elected from our constituents in the district. But believe me, to the public, is that we represent the entire city. So with only a few months left, 3, 4 months left, I would feel comfortable that it would be up to the council at that point, of course, but it's okay to leave it vacate. I did see Councilor Gishier raise his hands up earlier. Councilor Gishier, do you have anything else to add?
Thank you, Chairman Chow. I'm always concerned when a board appoints its own person. I just think that it's the public's position to do that, and that is always concerning to me to see a board would appoint someone to their own club. Because that's what it feels like in the end. And I do think that there's some merit if you look at Worcester's right now that already passed through a House petition that says the person who comes in second at the at-large or just outside being elected would be automatically appointed. And it says the same for district people. And what it says in there is that if somebody didn't have any opposition, that would go to special election. And I just think that where the city's tight on funds, and it may even invite more people to run, because then they know there is an opportunity, if they do come in second, to be able to join the council. I don't think it's fair that we just decide we're going to appoint somebody or have a special election, as all of us know how hard it is to go out, and not everybody puts in the same effort. We all know that about campaigning, but it's really, they put their name on the line. And here they are, and maybe their district really doesn't want them, but maybe there's a close race also. So, I mean, I do understand what Councilor Scott is actually saying is that, look, you know what, if you only get 20 votes and someone gets 3,000, is it really fair if someone leaves at 3,000 and there's only 20 people? But at the same time, I just think that somebody put their name on the line and other people just walked away. And maybe there are, as Councilor Leahy said, there are people who don't put their name on because they're, close to the person who's actually running for council, but they really would like to be a councilor too. So I see merit in what everyone's saying here. I just would caution against the appointment of a body such as the council appointing their own person to come in. I just don't think that's fair. I think that it's a special election, or do exactly what you said, Councilor Chow. Just wait till the next election if it's that close. Thank you.
Councilor Leahy?
Thank you. I'd like to take a look at the law department drafting up what Council Scott brought in about Watertown. Take a look at what they do. And again, we can tweak it. So if it gets into the 12th or 13th month, 14th month, 15th month, we can hold off on a special election. We can let it go to the November election. We could easily make our own rule up that in the special circumstance that person that does get elected in November immediately gets sworn in till waiting till January. So we can do what we need. But I think across the board, special election, the first X amount of months, 12, 13, 14, or 15 months would be the way to go. So I'm looking forward to seeing the report. And again, if it does come up in a district or wherever that we have the empty seat and it gets too late into the election season, we could ask the solicitor, but I think we could easily swear that person in right after the election. Thank you.
Councilor Dakota?
Getting back to Councilor Gitchier's comments, which have merit, I do agree, Councilor. I do have a problem myself voting in, your buddies into the club, basically. But I'm not sure if I heard you correct, and Councilor Gitchier, correct me if I'm wrong, but were you also looking at it from a citywide perspective? So let's say the fourth place person, but then I've gotten calls this week. How about if that person is not from that district? So you've lost district representation. Now, there's a very fine gray line there. I understand, that person is, like Chairman Childs had says that, we are district represented, but we work for the city, all of us, all 11 of us. But maybe you can help me with what I said there.
No, you would have to run for that district seat to be considered. You wouldn't
what I
come in fourth place and live in Belvedere, and if Council Leahy left, that wouldn't put you automatically into a district seat. You'd have to actually run for the seat that is actually being open, not.
So if you had no citywide
Right.
councilors from that district,
Right.
then you're saying to go,
Well, that's their choice whether to run for district or council, right, or at large. I mean, that's.
well, if
the
they're
choice.
large and they're not from that district, is what I'm saying, what is your remedy?
I think that if someone came in second place, it's the way Worcester writes it, is that if you came in second place in the district as a district running person, then you would be appointed over no matter who came in fourth place at the at-large, whether they were from your district or not.
You're the only one running for that district.
Say that again?
So what I'm saying is if nobody else came in second place in that district, what would you do?
Then it would have to go to a special election and you would run, right?
But what I'm saying is, I'm getting, all right, it's October of the second year.
Yeah, you're right.
We want to go to a special election, and, all right, we get somebody, and they come to one meeting, and they're out.
Yeah.
So I think it's very gray, I guess, at this point, but I'll leave it at that.
Councilor Scott?
Just one more comment as far as Councilor Gitchier's comments. I certainly thought about what you had said, but one of the things that I did suggest we change for Watertown is that I think it should be a 2/3 majority to appoint somebody also instead of a simple majority, just because that also puts a little bit more, we were elected to represent the citizens in our district at large, so we are a voice for them. And I do understand what you're saying as far as, not wanting to make that decision for them, which is why I think we should have the special election to give them the voice. And I do think, I played a little bit between the idea of 12 months or 18 months for the special election. That's something we also could talk about. We could talk about doing the 18 months for a special election, and we could talk about just leaving the seat vacant the last up to 6 months, I guess. That could be another option. Thank you.
Mr. Solicitor?
So does it make sense for me to bring back a report that has as many scenarios as I can strike that, and I see Councilor Gish's laughing. An
careful
appropriate amount of
be careful
scenarios.
what you say, City.
An appropriate amount of scenarios for, the body to consider and look at and discuss.
Councilor Scott?
Yeah, I'd make that in the form of a motion if you could bring back multiple scenarios. I know I also pointed out Chelsea has a scenario where you have to have at least 30% of the overall ballot cast within your district or at large in order to get the second place seat. So that's another option that we could look at. But any option we look at, like I said, should be, getting residents' voices involved with what they want within their district or at large. So, thank you.
Before I call on a second on that, when you bring back scenarios, I think, Mr. Solis, it could be, a lot of scenarios for the body to vote at the next meeting regarding this matter, no matter when. But I think, if you were to work on, I would support that motion too, but I think in terms of the scenario, I think there's pretty much like some basic important issues that we want to include with the time frame of the residency. I would imagine the residency would be the same thing as it was to be the initial election. If it was to be a district, the person running would have to be a resident of more than 12 months also. So maybe, there's not so many scenarios out there that would be confusing to everybody. So the language to come back, that would be the language that we would want to have the city manager forward to the state legislators. With that said, motion is second by Councilor Dakota. All in favor, say aye. Opposed, say no. The ayes have it. Motion is passed. Any other comments on this procedure to fill a vacant council seat? Here now, we now move on to the second item on the agenda for tonight, which is on the procedure to censure a member of the body. And also, the solicitor did prepare a report to present to the body at the last meeting as well. Just in case somebody out there didn't follow that meeting, Mr. Solicitor, could you give us a brief synopsis of that report from that meeting?
Yes, thank you. So, summary, to kind of get down to the meat and potatoes of it here, I cited City of Haverhill. They specifically have a city council rule that addresses censure. It walks through their steps on how they go about it. I think, obviously, this is something that needs to be discussed more here, but the city can tailor something close to this. I would have a few suggestions, at least at the outset, on some changes I would make from Haverhill's. But generally speaking, the censure, it's the body coming forward and formalizing certain behavior by another counselor that they don't agree with or that runs afoul of the council's, I guess code of conduct was used earlier, but certain behaviors and a manner in which a city councilor is expected to carry themselves. The city of Lowell doesn't currently have anything like that, so I figured a good starting point was just to show how the city of Haverhill does it, and maybe the conversation can sort of go from there.
Okay, thank you, Mr. Solicitor. So the basis of that report is that really the censure does not remove the elected official, it's just simply on public records. I do have a question what means public record, what that entails. Before I ask, I'm going to have my colleagues go first. Councilor Dakota.
Thank you, Chairman Chow. First off, I'd like to thank Deb Belanger for speaking. I want to make sure we're talking apples and apples and not apples and oranges here. So the censure I did read, and I do understand it. To be blunt, I feel like you're basically a slap on the wrist, basically, is what you're telling your colleague. Mike, I want to make sure I'm not putting words in my mouth, but Ms. Belanger then brought up code of conduct, which I don't think has anything to do with this censure at all. So if you could give me an explanation of that, is that something that the council would be able to do?
Yes, so as far as I'm aware, there isn't a Lowell City Council Code of Conduct, and that is something I imagine that would be developed probably in a subcommittee such as this. And I think where a code of conduct and censure sort of intersect would be other members of the body identifying one member doing something that doesn't fall or that, like I said, runs afoul to that code of conduct. So if there's an expectation of one thing or how certain things or how a counselor should act, carry themselves, something that differs from that could be a reason for censure. I think that is an area where they could sort of intersect. Now, I don't think it necessarily doesn't have to derive from a code of conduct. There are scenarios where I suppose a city council something could happen, whether it's inside here, outside here, that it is determined by the body is something that's worthy of censure. But it doesn't just have to come from a code of conduct. I think that's the most logical place to start in these scenarios, but where we don't have one, it would just sort of be handled on a case-by-case basis.
Okay.
You all set, Councilor Dakota?
I'll defer to my colleagues.
Okay. Councilor Scott?
Thank you. I think that actually would answer my question that I have when you gave us the copy of the Haverhill policy that says members of the city council must specify egregious behavior and/or conduct unbecoming of a city councilor. My question was, how does that get defined? I mean, does everybody put, an exact scenario of what the issues are with the person, or, is it done in executive session? How does that work? And I guess the code of conduct could answer that. They could point to specific violations of the code of conduct and call them out. Or do they just literally just take a vote of censure for bad behavior and not really say what that means? I don't know if you know how it's worked in other cities or towns that have actually censored somebody.
So with what I can say is that without a code of conduct, it certainly becomes a lot more subjective. But the idea would be if a member of the council wanted to bring forward a motion of censure, that's something that they would be able to speak on and other members of the body would be able to vote on. So yes, in that scenario, each individual time that this comes up would be voted on and dealt with. But I do think in a way that is an appropriate way to handle it, because the idea is whether it's majority, 2/3 of the body, they're going to vote either in agreement or disagreement with that one member bringing it forward. So I think it's an appropriate way to handle it, but with a code of conduct, it would take some of the subjectivity out of it. So it kind of depends which way you look at it.
Okay, and I would make a motion, I guess, sending work back to you, I guess, to also bring us examples of code of conduct that are in other, found in other cities and towns, examples that we could look at in addition to the language for filling a seat.
Okay, motion by Councilor Scott for the solicitor.
Second.
Through the city manager to present sample code of conduct as utilized by other municipalities. Second by Councilor Dakota. On favor say aye, opposed say no. The ayes have it. Motion is carried. Councilor Giccio.
Through you, Chairman Chow, to the city solicitor, have you ever seen in any other one where they actually put a hard line on what actually is the line on what the conduct is? Because is it yelling at your neighbor fighting over snow and someone videotapes you? Or is it, drunk driving? Is that one? What is the line that is being drawn? Because I do think there are definitely reasons to do it, but who decides what that line is and where is that line? Have you ever seen that in any?
Mr. Solicitor.
Thank you. So not to further complicate things, but no, there really isn't a line, and that goes to the subjectivity of this. It really is something that is different for everyone. I think people look at certain things and they may think a certain way, different from the person next to them. Now, the idea of it going in front of the body and giving all the other councilors the ability to vote on it, I think sort of is consistent with the subjectivity of it. But to answer your question, no, there really isn't a hard line as to something that would rise to the level of censure.
So I guess my question leads to this: can it be challenged at that point by? I know everything can be challenged, but where does it say that there? Because there's no convictions, there's no anything at that point. It's all speculatory. And then your peers are the ones doing this, right. And it could be, and I'm not saying it has been or it will be or anything, but there could be some moving pieces that are involved in doing this to somebody also.
And to your point, that could be worthy of something to go in the city council rule, maybe craft something for the ability to challenge the first motion that goes up. If it goes forward, maybe give someone in the dissent the ability to challenge it. I don't know. That's something we could certainly look at.
Because last time they did this, I believe Councilor Mercier was here when they started talking about this stuff, and it died off, and maybe like Councilor Leahy, and I wonder why it just went away. Could it have been that there's subjectivity to it and there's legal implications to this and more to that? So I guess I would defer to Councilor Mercier on those questions, because I wasn't here, and I just wonder, where that line and why it fell apart and why it's not here.
Just joining us also is Councilor Wayne Jeunesse. Councilor Mercier.
Thank you, Mr. Mayor. Sorry, Mr. Mayor. I mean, Mr. Chair, I should have said. I might have missed it, so I don't know if I'm being repetitive, but I want to ask this question. Whether it be any of these two issues to fill a vacant city council position or procedure to censure a member of the body, would any of these changes require legislative approval? Yes, it would.
Mr. Solicitor.
Thank you. Yes, so with filling the vacancies, some of these scenarios that were discussed tonight would require a home rule petition.
Right.
Yep.
That's what I thought, yeah.
Okay, also, Councilor Mercy, I just want to circle back, and I think this is connecting some of the comments that my colleagues already mentioned. What in your report to the council meeting the last time, Mr. Solicitor, you mentioned that that if the motion were to pass about censoring, it would be part of a public record. Can you define what that means? Public record could mean different things to different people. Would it be part of public record when somebody apply for, just talking generally, when somebody apply for a job, somebody would look at the public record with of some form, or in your report, it's just a report. When the censure motion passed, it's filed with the clerk, and if that would be the only case, what does it really mean? Who can access it? In what scenario would that become public, so to speak?
Sure. So I think generally speaking, it would be a public record, and that it would be a part of the minutes. And that's obviously, a less official mechanism, but that certainly would put it on the record. I think the way Haverhill does it, you actually put physically a document forward. So the way they have it crafted, when you put your motion forward, you actually hand in something that you have typed and put together that, from my understanding, gets filed with the clerk. At that point, it would be a public record, and anyone would have access to that. So I think, at least as it relates to being a public record, those are the two ways I see it being a public record.
Yeah. Thank you, Mr. And how long does it last? Is there like a statute that it become part of public record for 3 years, 5 years, 7 years? And how, I don't really know how many years the clerk keeps any, the public record regarding this. So, and something like this never happened before, what would be the statute be?
Well, I guess I'll answer this in two parts. First, we certainly, the council could put something in the actual rule that governed, it's in for a certain amount of time, year, 3 years, 5 years, I don't know. But in terms of a public record itself, I would defer to the clerk, but I believe once it gets filed with the clerk, it's there in perpetuity. So again, alterations could be made if you wanted to put time limits on it, but again, that would be up to the body.
I guess I will ask Mr. Clerk now. Mr. Clerk, obviously this never happened before, but if this were to pass and it were to happen, something like public document, how long would it, and how long would you hold it, and then?
Chairman Chow,
Yeah.
minutes are forever.
So you're talking in terms of, in this situation, you're referring to the minutes of the public meeting, basically. Any other comments or questions on this? Councilor Scott?
I just have one more question that was brought up by Ms. Belanger. And it's brought up to me by other people too when we're talking about censure. They're asking about a mechanism for someone relinquishing their seat. And I would just like to ask, I guess, Corey Williams, our attorney, whether or not there's any mechanism for a councilor ever losing their seat by an elected body.
No, so the only way that a city councilor could be removed from their seat is if they're convicted of a felony.
Thank you.
Any other comments or questions by any of my colleagues, even in the audience? Councilor Giccio?
Just one thing. I only say this stuff because I looked at the city councilor in Boston who clearly was convicted, going to be convicted. Clearly, they went to do the censoring and everything in between. He filed lawsuit, won thousands of dollars, and was convicted. So that's why I caution where we're going with this, because at some point, even though someone is even guilty, they still have the right, and maybe the solicitor can state the case because he probably knows that case, but there is a mechanism there that the city can be sued and lose funding because of improperly balanced. With what the solicitor said was about being a felony before you do these things. But if he can just comment just on that case so that we can understand where we're going before we get too far.
Any other comments, Mr. Solicitor?
Yes, thank you. So as Councilor Gishier said, it's the case is Turner versus City of Boston. And in that scenario, the city moved to remove him from his seat. before he was actually convicted of his felony. So the order of operations there was, as the Supreme Judicial Court found, was off. And that case, which also is in line with the state statute, but that case serves as precedent for the only way that someone can be removed from their seat is if they're convicted of a felony, and to do anything to try and remove someone before that happens is not allowed in the Commonwealth. So,
You all say, Councilor Goodyear. Any other comments or questions by the members up here or the councilors in the meeting? Any other comments or questions? Hearing none, I want to thank everyone for joining the meeting here in the chamber and watching us from home. A motion to adjourn by Councilor Dakota, second by Councilor Leahy. Your hand up.
I just want to make sure you were done with your business, but I just wanted to, I don't want to assume, the first motion we made about the filling of seats, that would also go for school committee too, I would assume. I just don't want to assume that, so, okay. Thank you.
Motion to adjourn, second by Councilor Scott. Motion is passed. Thank you, everyone. Have a good night.